number 168, in the matter of Diegelman versus the City of Buffalo. Thank you, sir. Good morning, counsel.
Good morning, Your Honors. John A. Collins for claimant appellant James Diegelman. And I would like to reserve 5 minutes of my 15 minutes allotted time.
You may have 5 minutes, sir.
Thank you.
You're welcome.
The resolution of this appeal, in which the Fourth Department held that the claimant's late notice of claim application should be denied because his claim was patently without merit, turns on one critical fact. Respondent City of Buffalo does not provide workers' compensation to its police officers.
That gets us to an interesting point. Let's assume you prevail. So you're going to sue the city, you're going to sue your employer, something that's kind of unheard of, but let's assume for the sake of this argument that it's going to happen. Do they have a lien?
I think one way or another there would not be any double recovery.
Well, that was kind of my question, because to read it the way you're reading it, and it's a good argument, but you're reading it literally, and literally there's no lien. So he's going to get all of his medical, all of his full pay, as opposed to comp, where you get the lesser amounts, and he gets to sue for that. So he gets double recovery. Pardon me. Plus conscious pain and suffering and everything else, right?
Well, I think the trial court would have to take into account the collateral source rule under CPLR 4545. He would not get paid twice for, and here he's a retiree, so they're really not talking about.
But the next one won't be.
The next one won't be, but there would be no double recoveries, I would submit, in any case, because of the workings of the collateral source rule.
What would the reason be for a municipality to have workers' comp other than to avoid these suits?
I don't know. Certainly avoiding these suits is a strong incentive, I would say. And
To have a whole system of workers' comp where a municipality is paying all these premiums just to avoid this rule?
Well, they may not pay premiums. They may well be self-insured.
But even then, doesn't that hurt the police officers? Pardon me, because comp is not going to pay them full pay.
No, I think officers in the general scheme of things would rely upon, if they are police officers, General Municipal Law 207-C, if they're firefighters, 207-A, get the benefits under that. But if they did rely upon the workers' compensation system, and certainly some cities, some towns, some municipalities, other than these major ones that were, at issue in this case, including the City of Buffalo, some do provide workers' comp.
But what's better for what's better for the police officer, 207 or workers' comp?
I would say 207.
Without question. And what you're arguing is we have this great benefit, better than comp, but we want to sue our employer because it's not mentioned. It's mentioned in 205, but not 207. And because of that, as Judge Garcia is suggesting, the city is going to say, this is crazy. I mean, we're getting sued by our police officers for what happened. We got to go to comp, and we got to compromise all of our other officers and those in the future because of this. Does that make sense to you? I realize you're not a mayor, but
I don't think there would be any compromise involved in.
I thought you said the comp was not as good as 207.
But the officers would get the benefits under 207. In other
Right,
words,
and
they would not be collecting comp benefits. And
The
if
comp
they did,
policy is just an insurance policy against getting sued. It really has no effect whatsoever because you're still getting the 207 benefits. So the only reason I can see that you would get a comp policy is to insure yourself against these lawsuits.
well, that may well be the case, but the legislature recognized that in 1996, and there is a very extensive, I think unusually extensive legislative history
I've
here.
seen it, but if we get away from the statute and just think in the way Judge Piggott is saying this, what could be the possible justification for allowing these suits where the plaintiff has better benefits than workers' comp? What would be the reason for doing that?
I think what the legislature implicitly, but obviously had in mind was recovery for pain and suffering, which is what you don't get under the workers' compensation system, which is what you don't get under GML 207-A or 207-C. And essentially, these suits turn into suits where you can recover for pain and suffering.
Well,
Because
don't we have that situation in the first department?
we certainly have it in every first and second department dealing in cases where we're talking about New York City police
Right.
officers.
It's kind of a
and
strange
firefighters.
situation, because in New York City, we have an administrative rule which is the equivalent of 207, right?
Correct.
And that equivalent rule means that this system is in effect in the largest city in the country that you're talking about right now. What's the experience there? I looked at a few cases, Gammons, there were a few cases I looked at. It seemed to be what the judge was just saying, that in essence that you're suing for pain and suffering here, and that you would insure against that.
Yes.
Is that what happens in the city, Mr. Collins?
That's my understanding from reading the Gonzalez case, the Weiner case, the Gammons case, is that yes.
So
the
we
injured-
have basically two systems in the state right now. One, the largest, the police and the firefighters in the largest city in the state have one rule, and everybody else in the smaller municipalities have a different rule.
They do, and the only distinction between the two is that in New York City, as Your Honor pointed out, they're dealing with several provisions of the administrative code that provide materially the same relief and benefits that are provided outside of the city under
I didn't think
the
either
207.
side distinguished. Both sides seem to treat those as equivalent. Your opponent can address that, but it seemed to be that they treated them as equivalent.
Yes, they're getting full medical coverage,
Salary.
and they're getting lost wage coverage, a benefit that exceeds workers' compensation. And it's been that way apparently in New York City with special administrative provisions since at least 1920.
But that's always been the case. They always say, cities of more than 1 million or cities not wholly contained within a county in order to treat New York City differently.
Yes.
We're up here, and I get the firefighters rule where, if as a result of someone else's negligence, a firefighter or a police officer is injured, they can pursue a case against that tortfeasor. But it's never been the employer, has it?
It has in New York City, certainly.
Well, I understand that.
And it should be here because there is no arguable legal distinction between how New York City.
Well, except the statute says it. It says that, in cities less than 1 million, this is the rule. And they're bigger.
Well, the statute is 207A and C, and they are the provisions that deal with cities less than 1 million. And what they do in those statutes is give police officers and firefighters in Buffalo, Poughkeepsie, whatever, the same benefits essentially that police and fire personnel are getting in New York City under the administrative code. But neither of those provisions states, and these payments shall be deemed the equivalent of workers' compensation.
Which gets back to my lien question, and you say that it's not a lien, except that it can be used under 4545 of the CPLR to offset a verdict.
Right. I mean, I have not seen in the statutes any language that says it's a lien. But again, yes, there would be no double recovery. And to get back to the 1996 legislative history, the Senate sponsor, in his message, urging passage of the 1996 amendments, said that subject to the limitations of the worker compensation law, employers and co-employees will remain liable to injured police officers under Section 205E. The bill opponents vigorously opposed that, pointing out that it would result in liability for the municipalities that don't provide workers' comp, including not only New York City, but, and acknowledging that they're essentially treated the same, although the benefits are paid under either the administrative code or 207, Buffalo, Syracuse, Rochester. This was 20 years ago. Governor Pataki said, essentially, so be it.
In fact, every time we've tried to limit the impact of the statute, the legislature has gone back and clarified it to
Yes.
contradict what this court has done.
Yeah, this court has, come to acknowledge that we get it. The legislature wants this provision applied expansively as possible. And in the city of New York, suits against the city for, sidewalk defects that an officer trips on, a firefighter trips on, a broken railing, whatever, the city is a defendant. What do they end up paying for? That they wouldn't pay for under the administrative code, paid in suffering. And the same result should obtain under Section 205E for, which applies in New York City, applies here. And it should obtain under 207 as well.
Counsel, I see your light is on, but I just have one, very small question. And just to clarify, you're suing the Board of Ed as well, but this police officer seemed to work in police precincts. Is the Board of Ed own some of these precinct buildings? Is that?
That was what our initial investigation determined, is that there might have been some ownership connection. I'm not sure how that's going to pan out. The critical issue, I think, on appeal is really the municipal liability. But assuming that the Board of Ed did own some of these properties, I submit that the Fourth Department erred in saying that the claim against it would be patently without merit, because as a non-employer, it wouldn't be entitled to the so-called comp defense, even if that defense were applicable.
Was that argument preserved? Did you argue that?
It didn't get argued as such, really, because in both of our briefs before the appellate division, the argument really focused on the city of Buffalo and the defense. The city at that point was the appellant, and in their brief they argued that the claim against the city of Buffalo should have been denied outright as patently meritless based upon the arguments we've discussed here. And so that was the focus of it, and they didn't really make a distinction between the city and the Board of Education. And our brief, again, focused upon the argument that they had raised on appeal.
Thank you, Mr. Collins. Counsel?
Good morning, Your Honors. My name is David Lee, and I represent the respondents, City of Buffalo and Board of Education on this appeal.
How could the legislature be any clearer about what they expect, how they expect this statute to be interpreted?
I think, Your Honor, that perhaps the legislative history regarding the 1996 amendments to Section 205E is completely misleading. I think what you have to do is you have
Well,
to...
it's not just the 1996 amendments. There have been 3 or 4 amendments along the way. Every time this court has tried to restrict the application of the statute, the legislature has come back and changed it and made it clear that that was not its intention. And so even if you could read the legislative history of the 1996 amendments another way, isn't it consistent to read it the way that
Well, I
the
think
claimant
that...
is arguing?
I think that the legislature, I think I have to concede that point, that the legislature has taught this court to read the statute expansively. However, I'm not sure that the legislature, perhaps in the new amendments, ever really looked back to the original enactment of the statute back in 1989.
But we can't, you're then arguing, saying, well, they made a mistake. If they had it to do over again, they would have done it the way you prefer it to be done. But isn't Mr. Collins right? I mean, if you read the thing, they can sue their employer.
No, I don't think they can. I mean, I think that, I'm trying to deal with this legislative history the very best that I can, and the way that the best way to do it, I think, is to go back to that 1989 enactment where municipalities were absolutely concerned about the legal relationship between an employer and an employee. Therefore, that workers' compensation language was added. In fact, my understanding of the legislative history is that without that provision in there, the bill never even passed. So
The 96 amendment seems to undermine that argument. 96, right? And I think it's 96. The 96 amendment seems to really undermine that amendment. In the legislative history, it seems that they actually discussed this. I mean, Mayor Giuliani wrote a particular letter about the impacts. There were a number of things included in the record that seemed to undermine that argument.
That's correct, Judge, and Mayor Giuliani was absolutely wrong in his analysis of the law. When he said that this would expand the liability for municipalities that don't provide workers' compensation insurance, such as the city of Buffalo, that absolutely was not the state of the law in the Fourth Department. The Fourth Department was clear that it was viewed as basically the legal equivalent. 207C benefits were viewed as the legal equivalent of workers' compensation benefits for police officers. And I think the court was hitting on this in the beginning, that what is the rational basis for distinguishing between those municipalities that label their payments to police officers workers' compensation versus ones who don't.
So your argument depends on our assuming that 207 is essentially a workers' compensation provision.
And I think that is spelled out even in the case law, Your Honor, that it's workers' compensation for police officers, but there needs to be something extra for police officers. The legislature decided when they enacted 207A and 207C with respect to firefighters for 207A, because their jobs are really tough. And they're
Counsel,
more.
if we decide in your favor, what happens then to the police officers and firefighters in New York City?
It continues on the exact same way, because New York City is exempt from 207C. So I think that's the critical.
Why does that make sense?
It makes sense because New York City is treated differently. They have decided to enact their own administrative code and do this their own way, and as the court knows, New York City is treated differently I don't know if I can name them off the top of my head, but it seems like they're
But
treated
usually
differently
you
for a lot
think
of
there would
things.
be a rationale for that, and I haven't heard a rationale in this particular instance why it makes a difference if you're a police officer in New York City or in Buffalo.
Well, normally the kind of rationale we're talking about is it would be affected by size or economic costs. For instance, differences in salaries within a salary structure throughout the state, or the size of the city demands certain things. But there doesn't seem to be that kind of rationale here, I guess, is what I'm looking for. I can think of many reasons how you could distinguish between the cities, and from a policy point of view, it would make sense. But here, I don't really understand the distinction.
Well, I think the distinction is that New York City does it their own way, and they're specifically exempt from what I would call the workers' compensation statute for police officers in New York State, which is 207C. So, I mean,
That's if we had said your argument that they're equivalent. Most beneficiaries don't want workers' comp benefits, they want 207C benefits, right? Because they're worth more.
Yeah, I mean they are, and that's
That's the bottom line here. Yeah.
right. I mean, I guess what I would do is just get back to my original point. I think my strongest argument is, and what I really want to convey to this court, is that when 205E was originally enacted in 1989, municipalities were absolutely concerned about the employee being allowed to sue their municipal employer. And that concern was absolutely addressed with that last provision in 205E, which preserves the exclusivity provisions of the workers' compensation law. And I think the intent behind that wasn't to say, oh, well, some municipalities don't actually provide workers' compensation benefits to their employees, so we're going to treat them completely different. It was really just to ensure that an employee couldn't sue their municipal employer. And I think the legislative history attached to my brief for the 1989 enactment spells that out.
Why not just say that? Why not just say that?
I think the
You
language.
don't get to sue your municipal employer, period, done. Why have all the rest of the language?
And interestingly enough, they did say that in 1996 when they enacted the General Obligations Law section, which basically completely abolished the firefighters rule. They did it more clearly in 1996, but the intent was always the same. Employees should not be allowed to sue their employers in tort when they are receiving workers' compensation benefits. That they're labeled 207C benefits, I mean, what is the difference?
Well, the difference is that in 205E, it says, provided, however, that nothing in this section shall be deemed to expand or restrict any right afforded to or limitation imposed upon an employer for an employee by virtue of the provisions of the workers' compensation law. That's not in 207.
That's true, Your Honor. That 205E doesn't say 207C, you mean?
Right, 205 says it, 207 does not.
Yeah, 207, well, and 205 is enacted after 207. That could have something to do with it.
Thank you, sir.
Okay, thank you.
Just very briefly, Your Honors, the general municipal law is distinct from and is not part of the workers' compensation law. And the only exemption granted to municipalities under 205E and for firefighters, the analogous 205A, as this court determined, was if you're covered by workers' compensation as an employee, you can't sue your employer. If you are not covered by workers' compensation, you can sue under 205A or E. And the distinction between workers' compensation and benefits payable under 207 A, or rather, yeah, A and C, was made manifest in Workers' Compensation Law, Section 30, which I cite in my reply brief, which states that no benefits independent of the provisions of this chapter shall be considered except, and it goes on to state that an award of compensation paid under 207A or 207C shall be deemed a credit against workers' compensation. Now, whether that will ever have any practical effect because the benefits under 207A and C are greater than workers' comp is questionable, but the statute is significant because it does note that and identify those payments as benefits independent of the provisions of this chapter, meaning Chapter 67,
So if I could
workers'
just clarify,
compensation.
so it is your first position that the statutory scheme is clear on its face, don't even need to look at the legislative history, but if we don't agree with that, the legislative history establishes your position that this is exactly what the legislature
The
meant,
legislative
and everyone
history-
understands that.
The legislative history just nails it down. Yes, sir.
But is your first position that the language is plain? We don't even need to look at the history.
Yes, it is, and I know the court generally will look at the plain language, not look at legislative history if it doesn't have to. Here, I think it is plain, but if you do look at it, it just, solidly supports that. Thank you.
Thank you, counsel.